Well, g'day again. Today we're going to have a look at a couple of words that some of you may not be aware of the hidden meanings in these words and how they have been getting us into trouble. So once again, we'll have a look at, start off with New Zealand Law Dictionary, 8th edition. And we're going to look at charge, the address delivered by the presiding judge to the jurors, instructing them in their duties. 2. A criminal accusation against any person. The Criminal Procedure Act 2011, Section 17.4 provides that the charge must contain sufficient particulars to fully and fairly inform the defendant of the substance of the offence that is alleged that the defendant has committed. Okay, now we're getting down to the meat and gravy here. 3. An encumbrance on land or on a fund. A registered mortgage under the Land Transfer Act has effect as a security. There's three words there that are quite important. So let's first look at an encumbrance. It's a charge or a mortgage upon real or personal estate. Now we know that we're the land and we know that we have a fund set up in the name of the father. So the Doe Trust is the fund, but the encumbrance is on land, which is us. So let's have a look at the final bit. It's a commission, an expense, or a cost. Okay, but our Treasury Direct account and the land, which is us, is where the charge is against. But it gets even better. What is? I went to Investopedia, and what is a warrant? Warrants are a derivative now that gives the right, but not the obligation to buy or sell a security. Now we are the securities, so let's have a look at what a derivative is. Once again, I go to Investopedia, which seems to be the best place to get definitions for anything as far as securities and that sort of thing goes. A derivative is a financial security with a value that is reliant upon or derived from an underlying asset. Okay, the asset is us, and the assets that we have is our Treasury Direct account. So a warrant is a charge against us or our Treasury Direct account. So it can be against either. So we're going to perhaps look at how we might change or turn the tables a little bit. A document authorizing some action, especially the payment of money. They're not hiding anything. A warehouse warrant is issued when goods are taken into a public warehouse and must be produced when they are removed. This document is negotiable and transferable by endorsement. Now, whenever they give us a warrant, warrant for your arrest, warrant to search property, or anything like that, they don't actually give us the document because that document is negotiable and transferable. Now, they've never told us that, so we're finding this out now that we can negotiate or transfer the document. I'll let you read that. Just pause it for a minute there and have a look, and we'll move on to the next thing, which is the form that we find in the High Court rules. Form 87, application for warrant of arrest. So this is addressed to the registrar of the High Court at whatever place it is, and the plaintiff is applying for a warrant of arrest. Now, the plaintiff is the person who is laying the claim or laying the charges against us or our property. We'll find out shortly that it's not against us, okay? But if we move down a little bit here, we'll find I certified, according to the records of the court, a notice of proceeding in an action in rem has been issued against the name of the ship, okay? So what is in rem? In rem is Latin for in the thing itself. A lawsuit against an item of property, not against a person. Against a person is in personam. So a lawsuit against an item of property. So the front of this uh, application is actually a check. So we'll show you what to do a little bit later. So once again, we'll go to the New Zealand Law Dictionary. In rem, Latin, in the thing itself. And we get all hissy fit and think it's against us, but no, that's In personam is different to in rem. A lawsuit against an item of property, not against a person. Actions in rem are generally instituted to tie claims to some property or title or status. For instance, where it is sought to gindium a ship in a court, and they do regard us as ships. So, going further into Black's Law Dictionary, the 5th edition, in rem, a technical term used to designate proceeding or actions instituted against the thing. An action in rem is a proceeding that takes no cognizance of owner, but determines right in specific property. So I'll let you read the rest of that. Just pause the video from time to time and read through the rest of them. But this is all about title, okay? And because we haven't secured our rights to the title, we're getting robbed. Okay, so in America they have a title guarantee company. We don't have them here in New Zealand. I don't think they have them in Australia either, but it's a business organisation which searches title to determine whether any defects or encumbrances are records, and which then gives the buyer of the property or the mortgagee a guarantee of title. So if you do not have a lien on the title, then commissioned agents can legally plunder your estate. But we can put a lien over the title, and you can do that on the PPSR or by patent, or you could put a claim of right in to secure or put a lien. Once you put a lien over the title, they can't come in and plunder. So the first thing they will do in America is go to the title guarantee company and see whether there is something. They will do it on the UCC in America, but here in New Zealand and Australia, Canada, England, we'll do it on the PPSR. All right, so if you do not have a lien on your title and an action that has begun against the thing, then you're going to have to try and make payment. We'll see if we can smooth this out a little bit for you. As all paper is money, then we will have to find the paper which started the action. We will need to get the warrant and endorse the back of it to allow the commissioned agents to pay themselves out of our Treasury Direct account. Quite a simple process, but quite a complicated process. So we'll have to have a look at endorsement to find out what we're going to have to do so that they can get paid. Now, there's two spellings of the word. Endorsement is English and endorsement is American, but both the same thing. Endorse, the person to whom a negotiable instrument, promissory note, bill of lading is assigned by endorsement. The act of a payee, drawee, accommodation endorser, or holder of bill, note, check, or other negotiable instrument in writing his name upon the back of the same. Once again, I'll let you read the rest of that and we'll move on to New Zealand Law Dictionary, 8th edition. The endorsement, a writing on the back of a document. Thus, we speak of an endorsement on a deed, on a bill of exchange, or on a writ. Now, the warrant is a bill of exchange. So the Bills of Exchange Act 1908, Section 2 states that the endorsement means an endorsement completed by delivery, and Section 32 outlines the requisites of a valid endorsement. Endorsement in blank is where a person to whom a bill or note is payable simply writes his or her name on the back. The effect of such an endorsement is that the right to sue upon the bill will be transferred to any person to whom the bill is delivered. So they get the right to sue. If you simply write your name on the back, which is what the banks do when you take a check and they say, just get you to endorse the back of this check. Mind you, some of you young people probably don't even know what a check is because they don't get used that much lately. But if you just sign the back of it, then the bank becomes the one that can sue or take the money out of our account. Now, this is Section 32 of the Bills of Exchange Act, just to show you. I'll let you read through that because I'm not going to go reading everything out and just be a talking head. So feel free to pause the video and just have a look at that. Now, New Zealand Law Dictionary, 8th edition, once again. Endorsement in full, an endorsement directing payment of the bill to a specified person or his or her on or his or her order. Such person is thereupon called the endorsee. So if we sign in full, endorse the back in full, then the endorsee is the person that we deliver this to will be the trust. In the case of endorsement in full, the bill or note, in order to become transferable, must be again endorsed by the endorsee. So the endorsee, which is the trust, can be signed PP. Okay, now here's a check. Okay, now on the back of the check, now we haven't actually tried this yet, so I'm just telling you this was how a banker told me that you sign, you endorse the back for a company. So paid to the order of, and PP means power of attorney, ABC Limited. So in the case of us, it would be paid to the order of Doe Trust, and then we will endorse that, put a stamp down the bottom, pay our stamp duty of 5 cents. Now this one was how the banker said that it was for an individual, paid to the order of, for and on behalf of John Henry Doe. Okay, so those are the two ways. Now once again, I'll say that we haven't tried this, we've only just come across this information and we're about to try it. So if it works, it's going to be great. But we're going to ask you to add your thoughts, comments below. If any of you know anything about this process, please feel free to write it in the comments below and share the information freely with everyone else. Thank you guys. Have a great day.